Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers and Lay People podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. I graduated law school in 2006 from Georgia State University here in Atlanta, and I've been practicing as a lawyer for almost 17 years. I'm a personal injury and bankruptcy attorney as well as a registered mediator. Today, we're joined by Justin Holcombe. Justin is a partner at Skaar and Feagle, LLP. Their website is scarandfeagle.com. His practice focuses on the litigation of consumer rights cases, both individual and class actions, involving credit discrimination, credit reporting errors due to the reporting of false or obsolete information, denial of employment or promotions due to erroneous criminal background searches, unsolicited telephone calls or text messages, do not call list violations, unauthorized payment transfers and billing errors, improper repossessions, and abusive or illegal collection activity. He is a member of the National Association of Consumer Advocates and regularly presents on a multitude of consumer rights issues at the National Consumer Law Center's annual Consumer Rights Litigation Conference. Justin received his BA in Political Science from the University of Georgia and his JD from Georgia State University. Well, Justin, thank you for joining the podcast today.
Thank you for having me.
So, what is it you like about practicing consumer law?
Well, I kind of view myself as a bit of a Robin Hood. You know, I help people who are struggling for whatever reason financially, either inaccurate credit reports, debt collection issues, telemarketing harassment. We help people take on the big companies, Goliath, and we try to be the little guy that takes on the big guys.
So, we're going to kind of get to all the various aspects of the technicalities that you can contest something. Let's just start with debt collection defense. So when you get a call from a client who's just been sued by a creditor, first off, are the kind of cases y'all handle, are these mainly magistrate, small claims court, or are they state court?
It ranges the gamut. Some are state court cases, some are magistrate court cases. I would say that probably 80% are in the magistrate court. But the cases that are larger than $15,000, they can't be filed in magistrate court because of jurisdictional limits. And then there's some creditors, mostly with out-of-state attorneys, who don't like filing in magistrate court because it requires an appearance. And so they like to file everything in state court where they can try to file motions without having to appear in court.
So when you get that first call, what are the steps you go through with the client to determine if this is just a legitimate debt they owe without a real defense and we need to look at settlement versus here are some of the issues that are wrong with the plaintiff's case that we can attack?
In pretty much any debt buyer case, which means you're being sued by someone other than the entity in which you obtained the loan, there's going to be defenses. They have to prove, I always use the analogy that if you owe your mother $20 and your next door neighbor comes over and knocks on your door and says, hey, your mom told me to collect that $20 you owe me, you'd probably say, what? You're going to need I'm going to need something more than you just telling me that I owe it to you and not to her. And so that's the thing. And the Georgia courts are very strict on how they have to prove their assignments and the documents they need to have in order to show the debt was incurred, the amount of the debt, the quality of the paper. There's a book that was written probably about 5 or 6 years ago by John Halpern called Bad Paper that talks about the quality of the paper in a lot of these transactions, and so there's a whole lot of defenses in pretty much any debt buyer case, and so we find those to be very defensible in almost every case. Now, original creditor cases, sometimes we see things that they've done wrong, and sometimes we have counterclaims, but the vast majority of those are cases where we're probably looking to settle if you're being sued by the party in which you obtained the loan.
So let's say you look at the complaint and you can just see from the complaint itself that there's some sort of defense you can attack. How exactly does that case go from a litigation perspective? How long does it take? What are your sort of retainer fees? How does that work?
Well, the retainer fees are the first thing we're going to do is we're going to interview the client, and we're going to look at the complaint, and we're going to figure out what kind of defenses are out there, and our fee is going to be fact determinable on the complaint. Now, if this is a case, let's say it's a debt buyer case, and it's filed in magistrate court, which the majority of these cases are, then what we're looking at is if a client calls us and they say, hey, I never took out this loan. Well, in that case, we're probably, if we believe the client to be truthful and we can get evidence that backs that up, we're probably going to take that case, on a contingency, and we're going to assert a counterclaim because, hey, this is a debt that was never owed, and we're going to probably try to collect money from the other side. Now, on the other hand, if the client says, I had this debt, I think they're seeking to collect a little bit more than I owe, I don't know what these transactions are, or hey, I don't think, I think that there may be something else, or they're just not sure, or those kind of cases, or what we're usually looking to do is we're going to charge a fee, usually of a percentage of what's owed, because the more that's owed, there's more work that goes into the case. But usually it's around 20%. Now, sometimes we'll work out a deal where we charge a little less, but we'll take a percentage of what we save you in settlement. But usually there's exceptions, but in the vast majority of cases, we do not make recommendations to our clients to pay money in debt buyer cases. Our goal is to have the only money they pay what they pay us in our fee, and to get the other side to go away.
And when you say you got a debt buyer case and there are usually some sort of claims you can assert, can you just be more specific? Like what typically is is this a FDCPA claim, or like what typically are the common defenses in the debt buyer cases?
Well, again, the first thing I said is we look at the assignments. So that's the first thing, is the quality of the paperwork, the assignments. And then the second thing is, okay, they have the assignment. Can they prove the contract? Can they prove the terms of the contract that they're seeking to collect upon, including their rights to collect things like interest, accelerate the balance, and all those types of things. And then the other things that we're looking for is, can they show what the balance is? Because a lot of times they just buy a charge-off statement and they don't have the underlying records to show that the balance was owed. So if they just have a charge-off statement that says you owe $3,000, and we ask for the underlying records to show how that balance was accumulated, and they can't provide that, and then they can't. And all we're seeing is on the statement, as far as charges are added on fees, but they don't have the contract that entitles them to collect those fees, then that's a problem.
So is it pretty much more from a paperwork standpoint that it really comes down to what the creditor has, or is there things that your client can give you or needs to have on their end that can assist the case?
Well, most people don't keep their credit card statements. I think that the advice of most people is to shred them for identity theft purposes. And so, usually they don't have a lot, but the issues are if you have disputed transactions, the Fair Credit Billing Act allows you to dispute a transaction on say, a credit card statement. And so if there's a transaction, a billing error, which can be anything from, I ordered something online and I didn't receive it, or I got double charged, or I didn't authorize this transaction. Those types of billing errors that usually result in what we call chargebacks. If those things aren't resolved in your favor, now those can create affirmative claims. So if you have evidence of prior disputes and those types of things, those are important to have. But in most cases, the papers that they're served with are the only documents that the consumer is going to have. And so we're looking at what does the other side have, and that's how we're defending the case, because the plaintiff has a burden of proof.
And what about, you talked a little bit about the original creditor. What if it's an action from original creditor? How do you guys typically handle those defenses?
In those cases, we'll look for things that may be wrong. And sometimes we find things, but the vast majority of the time against an original creditor, Most of these banks, they keep good records. They're required to keep good records. And so if it's an original creditor case, our advice, now sometimes clients say, hey, we just want to go for it, and we'll go for them, and sometimes we'll win it, sometimes you'll lose it. And we'll do that. If a client wants to try the case, we'll go and try it. But the vast majority of those cases, we're looking to try to settle for the best deal that we can get.
Okay. Let's turn to FDCPA claims. What are some of the common collection efforts that creditors make that should either alert a consumer that they have a potential FDCPA claim, or that you typically see turn into be good FDCPA cases?
Well, anyone who is having issues with debt collectors, whether they're ringing their phone off the hook, they're getting a lot of letters, they're getting threats that they're going to sue you, or they're threats they're going to repossess your car, anything like that, we encourage you to contact us. We'll look over your correspondence, because we don't expect our clients to necessarily understand the details and nuances of the law, and to know that they're treating fairly and appropriately under the law. And so what we do is we're happy to review all of those things and to give someone specific advice if they're getting any kind of collection harassment or communications, if they're just unable to pay or they're behind and they just want us to look over their communications. We're happy to do so. That said, the typical FDCPA cases you see are ringing someone's phone off the hook, saying, hey, I can't be called at this time or at this place, or someone sends cease communication notice or refusal to pay notice, and there's continued communication. If someone makes a dispute, there's a 30-day dispute process under the Fair Debt Collection Practices Act. Someone makes a dispute and they continued collection attempts without providing verification. False threats, says, a lot of times, especially when you have some of these illegal loans anyways, like payday loans that people get online, because they can't sue because their loans aren't lawful, you see a lot of really heinous threats, like people threatening, we have the sheriff coming over, they're going to arrest you, or something like that. There are certain scams where someone will call pretending to be like a process server, and it's like, well, if you give this guy a call, then we're not going to come out or whatever else. But there's a lot of false threats. And so what we generally tell people is, first of all, if there's threats that you're going to be sued, that usually means you're not going to be sued. It's not 100%, but usually if someone's threatening to sue you, that means that they're using that to get you to pay them, because they have no lawful means of going after you. The folks that sue, the lawyers that sue, you'll get a letter from a local law firm that says, and that's going to be a letter, and then they'll sue you. And so worry about a threat to sue when the sheriff comes and hands you papers, not when you get a phone call. If someone's calling you threatening to sue, it's almost always a scam.
So let's say you get one of those threatening phone calls, and you have an actionable FDCPA claim. What are the type of damages you can collect, and how does it vary based on exactly what happened, how you were threatened, et cetera?
Well, the Fair Debt Collection Practices Act provides for one statutory damages of up to $1,000 for in any action if you prevail. And then it also provides for, in the case of a class action, for statutory damages of up to $500,000 or 1% of the company's net worth. In addition, you can collect your actual damages, which is general damages for things like anxiety, whatever type of kind of what we call non-economic damages, or usually they're out there. And sometimes there's economic damages, hard specials. But usually what we're looking at is, non-economic damages, which can also be trebled under the Fair Business Practices Act, which is a Georgia law that any violation of the FDCPA by a debt collector, it's going to be a violation of the Fair Business Practices Act off of a Georgia Court of Appeals decision. And so that leaves us, so we'll get treble damages and potentially punitive damages under the Georgia Act.
And from a client's perspective, if they've retained you and you're bringing an FDCPA claim, is it pretty much just you as the lawyer doing the work? Does the client really need to be doing anything during the case? How much effort are they putting in?
Well, the client needs to be aware of the case. The client's we're gonna send them a copy of the complaint. We're not gonna expect them to understand all the legalese, but the factual matters in there, we want to make sure that what we're telling the court is accurate, and we want the client to review it and sign off on it. And then after that, we're going to handle most of the settlement discussions, and we'll communicate those discussions to the client to the extent that those are happening. Ultimately, the decision to settle any matter belongs to the client, and so we will communicate that. We'll communicate any offers to the client. But for the most part, we're handling the details of the litigation. Now, will the client have to be prepared? In the event that there's not an early settlement, and we're going through discovery, the client will have to be there for their deposition, and we'll prepare the client for the deposition, and the client will have to assist in preparing responses to whatever discovery requests are sent to us. But it's usually the time to respond to discovery requests isn't too laborsome, whereas, and again, most cases settle before we get to that stage. But those where we're litigating out, it's usually not too burdensome. The worst part is usually a deposition, and those don't usually last more than a few hours.
So let's turn now to the Fair Credit Reporting Act, which I know is also a big part of your practice. And it's a hot topic of what to do in a situation where you don't think something's accurate in your credit report. A lot of stuff about it on the internet about how to handle it. So can you set the record straight? You got something wrong on your credit report. What is the wrong thing to do? What is the right thing to do?
Well, the first thing, before we get to there, I just want to point out that a lot of people think the Fair Credit Reporting Act, they think Equifax, TransUnion, Experian. There's hundreds of consumer reporting agencies out there, and it includes not just what we think of as typical credit reporting. It includes any type of credit background, any kind of screening for a consumer's creditworthiness, reputation, employment. So background checks, all kinds of things. Employment background checks. All potentially gun background checks. There's we had a client who had who wasn't able to coach Little League because of an inaccurate background check, and that was subject to the FCRA. And so just want to make sure that people understand that the FCRA isn't limited. A credit report or a consumer reporting agency isn't limited to what we think of as the big three. But with respect to the big three, the number one thing that I tell people is don't dispute accurate information. There is a lot of misinformation out there on the internet, as you were alluding to, where people say, hey, you can clean up your credit report by following, by disputing it this way and saying XYZ, which isn't true. And the problem with that is sometimes it works temporarily, but that stuff always comes back. And when you inevitably have something inaccurate, and there's 1,000 reasons why something can be inaccurate, you've lost credibility with the court, with the credit reporting agencies, and with any jury if you get that far. And it makes your case worth less if we can take it at all. And so the number one thing we say is if you have questions, we'll talk to you for free, but don't follow someone you see on TikTok that's telling you how to, information on how to dispute things or clear up your credit. Most of that stuff is wildly inaccurate.
So you mentioned the Little League coach scenario. What are some of the, maybe more uncommon, or at least things the layperson's not really thinking about, of ways that your credit report is impacting you and you can have a claim? Okay, well,
a lot of cases we see are employment background screening cases. Someone goes and they apply for a job, and there's inaccurate information on their background check. What's very common is you'll have two people with very similar names, live in a similar area, and so their information will show up on the other person's background check. So sometimes it's someone else's crime that's on your report, or sometimes it's father son that have the same name. We see that a lot where I have a case right now that's pending against a credit reporting agency, a class action in Pennsylvania, that relates to where the defendant credit reporting agency provided information, really damaging information about our client's son, and attributed it to the client, and so that client lost, had credit accounts closed because the creditor saw that he was engaged in organized crime when he was not.
Wow, that's pretty significant.
Yeah.
So that makes me think, a lot of these credit reporting things, they can't just be resolved right away. That chance
Yes.
for the job, it passed, or to get the mortgage or whatever. So how long does this kind of case typically last when it involves litigation, and what are the type of damages that can be had?
Well, the first step, credit reporting cases take a lot of preparation time beforehand. We'll walk someone through the process of appropriately disputing and trying to correct a credit report. If the credit reporting agencies and the furnishers are usually the creditors that are providing information to the credit reporting agencies, if they do the right thing and they follow the law and they correct someone's credit report, we've provided a free service and we're happy to do it. But when they don't do the right thing, and when you send detailed notices with factual information, with documents that show that what's being reported is inaccurate, and we'll walk you through the process of doing so and who to send the notices to. And the credit reporting agencies decide to farm out to some country either in South America or in East Asia or South Asia, and they farm out the dispute resolution work to people who maybe spend a few minutes on it sometimes. And again, this isn't every case. I don't want to say that that's what always happens, but it will happen sometimes. And so what we're seeing is if they don't do what they're supposed to do, and the consumer is sent dispute and they won't fix it, then at that point, then we'll file a claim under the Fair Credit Reporting Act, and they can receive their actual damages, which is both things like the non-economic damages we talked about before, the anxiety, the loss of sleep, the traditional things that we think of. But then there's also hard damages. Say you were denied credit, so we wanted you to hold on to any kind of adverse action letters that you've received. We don't want you going out applying for credit that you don't need or that you didn't want, but we ask that you just go about your life. And if if you're at the store and they offer you a discount for a card and you would have taken it, then try to get it. And if they tell you no, because of this information on a credit report, then that's those are damages. Of course, a lot of times we'll see people will get an interest rate that's higher, and so those are damages that we can recover. Now, the FCRA also provides for statutory damages as well, a minimum of $100 up to $1,000 if the violation was willful, and then there's also provision for punitive damages and for attorney's fees.
And so is this the same thing with the FDCPA, and that some of these can settle before discovery and then others will just drag on? Yes,
and a lot of that is just the type of case, how many disputes we have, the strength of the case, the amount of damages that are at stake. Large damages cases, they're usually going to drag out longer because when you're seeking a lot of damages, they're going to want a deposition. Like they're not going to pay what your case is worth without being assured that your case is worth what you say it's worth. But on some of the smaller cases where you're fixing an inaccuracy, what you're looking at usually a lot of times maybe 4 smaller dollar cases. So you'll have a case against, say, maybe each of the credit reporting agencies for the failure to properly reinvestigate a dispute, and then maybe a case against a furnisher for not properly responding to a dispute that they received from a consumer reporting agency. And so what you're looking at is usually maybe kind of 4, smaller, middle-sized, value cases, but together, they add up. So, and it gets your credit report fixed, and usually at the end you'll get a chance to review your corrected credit report, and they're going to want to make sure that you sign off that, yeah, everything here is accurate.
For sure. Let's turn to garnishment defense now.
Yes.
So when you guys at your firm get a call from a client who's just received a notice of garnishment,
Yes.
How often is it that they're just completely taken out of the blue? They've never heard of this creditor versus, okay, yeah, I remember that, and I remember they sued me and got that judgment, and okay, I just need to deal with it now.
They've usually, not always, if this was their debt. Now, there's cases where it wasn't their debt, and it's, they garnished the wrong person with a similar name. I mean, we've had that happen. But usually, if this was their debt, they'll recognize the creditor. The real question is, do they remember getting served? Do they remember the lawsuit? A lot of people move around a lot, and so the first thing we want to do is find out if they were properly served. Because if service was bad, then we can attack the judgment, and we can stay the garnishment while we go and attack the judgment. Because if there's no judgment, they can't submit a garnishment. And so the first thing we want to do is we want to look up the underlying file and see how someone was served. And usually the service paperwork is going to indicate notorious service. And sometimes it's personal service, but often what we see is notorious service. And so then we go and look, okay, so who was served? Did that person live with you at the time? Or did you live at the address where service happened? Because sometimes they'll have an old address. And so what we'll do is we'll look for a way of, we'll need documents to show that for whatever reason that the service wasn't good. And if there's no good service, then the judgment wasn't valid, and we can attack the underlying judgment. And so that's the first thing we look for is whether or not the judgment was good in the first place. And then the second is, how old is it? After 7 years, the judgment goes dormant if they haven't renewed it. And then there's a 3-year period where they can file a writ of stare decisis to renew that judgment. But sometimes we'll see people file garnishments on out-of-date judgments, and so that can be a defense. A lot of times what we'll see happen is someone moves to Georgia from another state, so they'll try to domesticate a judgment that's outside the limitations for domesticating a judgment here in Georgia. So that's something that we'll see sometimes. And then there's attached to the garnishment itself. And that can be anything from, you used to not know what most of these are, but after a case a few years ago brought by Atlanta Legal Aid against the clerk of court in Gwinnett County, that resulted in a case that overturned Georgia's old garnishment statute. And so Georgia had to completely rewrite its garnishment laws to comply with an order of the Northern District of Georgia. And to do that, they now provide you with a form that lists most of, not all, but most of the exemptions that a consumer can raise. And so there's a whole lot of exemptions, whether it could be a pension fund, money in an IRA. A lot of times we'll see someone will file a bank garnishment, and all the money in the bank account is either their spouse's money, because it's a joint bank account, or it's their wages. And while the federal wage protection doesn't maintain its protection once it's paid, the Georgia wage protection, when your wages hit your bank, they maintain the 25% protection. So 75% of your wages are protected, and they can only collect up to 25% or a minimum wage. So there's wage protections. So if they clean out the account, and all of your money in the account is wages, and then all the other money belongs to someone, say your partner, and there's another statute in Georgia that a joint account belongs during the lifetime of the parties to each in proportion to their net contribution. And so sometimes you'll see maybe a mom or a partner or whatever else that'll put all the money in the account, but someone else's name is on it so they can access the account. And those funds, even though that person can access the account, if they belong to to a stranger to the judgment, then they have a claim to those funds that's superior to that of the creditor that's trying to obtain those funds.
And that's even true to a married couple, I believe. Is that
Yes.
right? Yes. Just for our listeners, there is a judgment that's going to precede the garnishment, and the judgment is often going to be in a different county than the garnishment is. They don't have to be, but usually it's probably in a different county. So you've got multiple lawsuits going on, and the very first step is making sure that the initiating lawsuit that led to the judgment, that service was proper.
That's correct. And then, the garnishments, 95% of them were filed in Gwinnett County because they are very efficient at handling garnishments. And that's why it was the clerk of Gwinnett County that was sued by several years ago in the case that I was speaking of. So the vast majority of garnishments are filed in Gwinnett County because most registered agents of companies are in Gwinnett County, and that's, a garnishment is filed where they have jurisdiction over the garnishee.
Right. So the system where the process where you have an issue with the garnishment, now that's called a traverse, right? Where you're contesting something related to the garnishment.
Well, there's a traverse, and then there's also a claim. There's two different processes. Now, any time we're filing a claim, we will also file a traverse because that's what courts are used to seeing, and that's going to set up your right to an immediate hearing. And they have to give you the hearing. And if they don't give you the hearing within a specific time frame, they changed it recently, so I think it's still 10 days. But if they don't give you the hearing within a specific time frame, then they violated your due process rights.
Okay, so let's say you have that hearing.
Yes.
And there is an issue with, let's say, service in the underlying judgment. What is the judge going to stay the garnishment? Or likely, is the judge likely going to stay the garnishment or say the garnishment can continue, but we're holding the money in the registry of the court? Like, how does it immediately impact your client as far as, say, not having part of their wages garnished while this process plays out?
Unfortunately, what's usually going to happen is the court's going to stay the proceeding. Now, the garnishment itself is going to remain in effect, but no money it'll be paid to the court, and no money will be dispersed to the creditor. And so then what happens is the garnishment court doesn't have jurisdiction to determine the validity of the judgment. So we have to go back to the court that entered the judgment if we're going to challenge the underlying judgment. And so once that judge rules, you'll take it to the garnishment court, and or more generally, we usually just take it to the creditor's attorney. Before we go to the court. I mean, we can contest it with the court, but if once the trial court that issued the judgment's decided, there's really nothing to argue about, so we can usually resolve it with the other side.
Right. So before I let you go, I know your firm has other practice areas, Electronic Funds Transfer Act, Telephone Consumer Protection Act.
Yes.
Just explain to the listener what exactly goes into those acts, and like where do they how would they know they would potentially have a claim they need to contact you?
Electronic Funds Transfer Act. Now, those claims, there's really kind of a category of laws that I won't go into a whole lot of detail here that come into play. But what we're looking at in those cases is we found a proliferation recently of, especially with all the data breaches that have been out there that we've all heard about and we've all received letters about, of third-party criminal enterprises accessing people's accounts and transferring money around and then ultimately wiring funds out. Wire transfers are unfortunately not governed by most consumer protection statutes that apply to other types of transfers. So we have limited means to go after unlawful wire transfers, but we can go after them. But our remedies aren't as strong as they are with respect to any other type of electronic funds transfer. Where if someone's taking a cash advance from a credit card, it's governed by the Fair Credit Billing Act. But if someone accesses your checking account and say they're sending money via Zelle or Cash App or bank-to-bank transfer, any of those types of things are governed by the Electronic Funds Transfer Act, which can give you, actual damages, your money back, treble damages, punitive damages. I mean, so there's a bunch of other remedies that are out there for those type of things. But what we're looking for there is, people who have been a victim of fraudsters hacking into their financial accounts and stealing money from them. And so we're doing our best to go after these financial institutions and make them responsible for not having the security procedures in place to prevent fraudsters from improperly accessing accounts. And then the TCPA, the Telephone Consumer Protection Act, that's a large part of my personal practice. And that's there's kind of two main provisions that are out there. There's a robocall provision. Nobody can call your cell phone using an auto dialer or an artificial or pre-recorded voice without your prior express consent. Unfortunately, the U.S. Supreme Court has kind of gutted the auto dialer definition, so there's not a lot of auto dialer claims that are out there anymore. But artificial and pre-recorded voice claims are still out there. Whenever you get a call and you answer it on your cell phone, and it's not a human on the other end of the line, it's a computer talking to you, or a prior recording for any purpose, political, debt collection, whatever, telemarketing. Those calls are worth, if you haven't given your prior express consent, they're worth $500 a piece. It can be trebled to $1,500 a piece if the violation was willful. And then there's another provision that just applies to telemarketers, and that's if you're on the national do not call list, which you can go to donotcall.gov and register your telephone number, and they call your telephone number. And if you have a personal cell phone that's used for residential use, you can also register it as well as a residential number. But if they call your telephone number and you're on the do not call list for the purposes of a telephone solicitation, which is to sell you something, and you've never done business with this company, or you haven't done business in the last 18 months with this company, then that's a violation of the TCPA. And then that under the same subsection, there's also a company-specific do not call list, where if you have done business with a company, or you're not on the national do not call list, and you're getting calls from someone, and you say, hey, stop calling me, I don't want to receive calls anymore, they have to honor your do not call request, and they have to maintain specific procedures not to make telemarketing calls to people who have requested not to receive telemarketing calls from that entity. And those calls, again, can be worth between $500 and $1,500 a piece.
You said that's a big part of your practice.
Yes.
I can just picturing how many calls go out that violate that. How many of those cases do you take in a year?
We're selective on the cases that we take. We either want a lot of calls so that you have sufficient damages, because like I said, it's between $500 and $1,500 a call. I'm not suing over $500. So if you have a lot of calls, where sometimes we'll have people with 100 calls. Well, suddenly that's a viable case. But if you have a few calls, while I won't sue for you for $500, I will if you're willing to represent a class, and you're willing to say, hey, I don't like these calls. I want them to stop, and I want to send a message. If you're willing to represent a class, then we'll file it for you and everyone else they called, and we'll try to collect $500 to $1,500 for every single telemarketing call that they made.
Well, that was a wealth of information. I think the summary is there's a lot of potential claims out there, people doing things that consumers actually can take action upon. And, just if you think you've got a case like that, I'd recommend you reach out to Justin. I want to thank our guest, Justin Holcombe of Skaar and Feagle, LLP, for joining us on this podcast, and to thank you for listening. You can find Justin at skaarandfeagle.com, and I'm going to need to spell that. That's SKAARANDFEAGLE.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or whatever, or wherever. All of our contact information can be found in the link below. And for more details, you can personally email me at peter@brickslaw.com.